satellite Sputnik lifted at 22 hours 28 minutes Moscow time and entered orbit around the Earth.
The first artificial Earth satellite in the world has now been created.
Ladies and gentlemen, we are bringing to you the most important story of this century, mankind's breakthrough into space. For the first time, mankind has reached for the stars and found them within his grasp.
On October the 4th, 1957, Sputnik was launched.
Then its casing opened. The springs snapped, and the nose cone was pushed out of the way. A ball with 4 antennae emerged to go it alone in the darkness of space. And a radio began to send a signal back to Earth. Humanity had entered the space age.
You just saw one of the most significant events in the history of mankind. The launch by Soviet Union of Sputnik 1, the world's first artificial satellite. It marked the start of space age and the US-USSR space race. It ushered in a new political, technological, scientific, and legal development. It gave rise to space law, a body of legal rules dealing specifically with the matters relating to outer space. There is no agreement yet on the altitude where airspace ends and where outer space begins, but for the time being, this is not considered to be problematic. Space is occupied, so to speak, by satellites, aircrafts, planets, and celestial bodies. These bodies are still far higher than the highest aircraft can reach. So we cannot apply the rules of air law to space law because space is simply very, very different from the atmosphere. This raises a lot of questions, and I'm going to put some of them before you now. These are intriguing questions. As I ask them, pause the video and think about these questions. As we go further in this video, you will know the answers to these questions. So here goes. So the first question is, can any state own the outer space? Or if not the entire outer space, a part of outer space? Can any individual or a private entity like a company own outer space or a part of outer space? Are private entities allowed to carry out space activity like space exploration? You heard about SpaceX, right? What if astronauts in spacecraft suffer accident or they experience conditions of distress and make an emergency landing? What if a space shuttle or a space vehicle causes damage on the surface of Earth or to any aircraft? Is the launching state liable? How can we keep track of ever-increasing number of artificial objects floating through the space? And what about space trash? And one of the most interesting of all, who owns the moon? So let's begin today's class on the introduction of outer space law. Pay attention as I bring these questions for discussion throughout the video. Let's start with the origins of outer space law and move on gradually to trace major developments in outer space law. So after Sputnik was launched, there was a lot of discussion on the use of outer space. As a response to that, the United Nations Committee on Peaceful Uses of Outer Space, or COPUS for short, was established in 1959. This was a year after the launch of Sputnik. The mission of COPUS was, and I quote, to review the scope of international cooperation in peaceful uses of outer space, to devise programs in this field to be undertaken under United Nations auspices, to encourage continued research and the dissemination of information on outer space matters, and to study legal problems arising from the exploration of outer space." End quote. In 1962, Corpus formed two subcommittees. First was the Scientific and Technical Subcommittee, and the second was the Legal Committee. They met for the first time in 1962 and they continue to do so annually. Corpus oversees the implementation of 5 UN treaties and agreements relating to the activities in the outer space. We are going to know what these 5 major agreements are in due course of time. So, how it all started? A year after Sputnik was launched, the UN adopted the first important resolution on outer space. It suggested that mankind had common interest in outer space, remember res communis, and established the principle that outer space should only be used for peaceful purposes. 3 years later, in 1961, the UN General Assembly adopted another resolution, stating that outer space and celestial bodies were not subject to national appropriation, but were free for exploration and use by all states. The above principle were cemented in 1963 General Assembly resolution under the title Declaration of Legal Principles Governing the Activities of States in the Exploration and Use of Outer Space, and these still form the bedrock of international law of outer space. That declaration is not a binding treaty, but it summarized the consensus which was arrived after a serious debate. The main points were: first, space exploration and use of space were to be for the benefit of humankind. Second, states conducting activities related to space would be responsible for their acts. Third, all activity in space was to be guided by the principles of cooperation and mutual assistance. Fourth, states launching objects and personnel were to retain jurisdiction over them in space and on return to Earth, no matter where they might land. Fifth, states were to be liable for any damage on Earth, in airspace or outer space caused by objects launched by them into the outer space. And sixth, astronauts were to be considered envoys of humankind. In case of accidents, all states were to be bound to render them all possible assistance and to return them promptly to the state in which the space vehicle was registered.
The United Nations Office for Outer Space Affairs was there from the beginning of the space era, created just 1 year after the launch of Sputnik 1, with the aim of bringing the benefits of space to humankind. USA has assisted the Committee on the Peaceful Uses of Outer Space to promote international cooperation in space, leading to the adoption of the Outer Space Treaty, the first treaty in a series of 5 governing space-related activities, and 3 UN global conferences on outer space, Unispace 1, 2, and 3. The Outer Space Treaty recognises space explorers as envoys of humankind. For over 40 years, USA's Programme on Space Applications has provided practical assistance on the use of space technology for peaceful purposes throughout the world. The office also facilitates UN Space, a mechanism for UN entities to cooperate on the use of space technologies for sustainable development.
In the year 2000, a man named Gregory Nemitz registered a claim on an asteroid. He officially published his claim, and the claim was recorded and published by the Archimedes Institute, which is a non-profit institution. In addition to this, he also filed official documents with the California Secretary of State under the Uniform Commercial Code to establish a legal and equitable claim. 11 months later, NASA's spacecraft called Near Shoemaker landed on that asteroid. Gregory's company called Orbital Development issued NASA an invoice of $20 for parking the spacecraft at the asteroid. Let's read the communication that Gregory sent to NASA. Congratulations to you and Johns Hopkins University for Applied Physical Laboratories NEAR project team for NEAR Shoemaker's successful landing on Eros. The outstanding success of this feat is simply amazing. I have been following the spacecraft's progress for quite some time and do appreciate the information that was returned. By now, you may be aware that since March 3, 2000, Orbital Development is the owner of the property Eros. There is an article on space.com that mentions the details of Orbital Development's ownership. A press release on the matter is available at this website. I wish to your attention the small detail of parking/storage fee for the spacecraft. To help defray Orbital Development's costs for our ongoing Eros project, a storage fee is required for all grounded or orbiting spacecraft that do not leave Eros. The fee is presently $20 as per Earth Century. This fee is due within 20 days of landing or for the spacecraft remaining in orbit 21 days after exhaustion of fuel to a level that precludes leaving Eros orbit. This notice shall serve as an invoice. So, isn't this very interesting? What really happened here is a man is claiming ownership to a celestial body, an asteroid. And NASA actually replied to this communication. Let's read NASA's reply to this communication. Dear Mr. Nemitz, your letter of February 16, 2000 to NASA administrator has been forwarded to me for response. In that letter, you request a payment of $20 parking storage fees for NASA's near-Earth asteroid rendezvous Shoemaker spacecraft that landed on the asteroid 433 Eros on February 12th of this year. Your claim alleges that since March 3, 2000, Orbital Development has owned Eros by the virtue of property claim filed on that date with organization called Archimedes Institute. Notably absent from your letter is the citation to any legal basis for Orbital Development's claim to own Eros or to any legal significance of a filing with the Archimedes Institute. If you have any such information, please provide it as soon as possible. As you may be aware, the Article 2 of the Outer Space Treaty of 1967, to which the United States is a party, states, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use of occupation, or by any other means. If Orbital Development or its principals are US nationals, this treaty provision would seem to preclude any claim to own Eros. Therefore, NASA respectfully declines to make the requested payment at this time. So this is very interesting, isn't it? Now, this brings us to the first treaty or first convention that we are going to discuss in this class, that is the 1967 Outer Space Treaty. Now, the principles that I just spoke about in the UN Declaration of 1963, these principles were further cemented in the 1967 Outer Space Treaty, and these principles now, rather than being declaration, have become legally binding. Under the terms of Outer Space Treaty, in summary, the parties are prohibited from placing nuclear arms or other weapons of mass destruction in the orbit, in the moon, or any other bodies in the space. Nations cannot claim sovereignty over the moon or other celestial bodies. Nations are responsible for their activities in the space. They are liable for any damage caused by objects launched into space from their territory and are bound to assist astronauts in distress. Their space installations and vehicles shall be open on a reciprocal basis to representatives of other countries, and all parties agree to conduct outer space activity openly and in accordance with international law. So that was the summary of the Outer Space Treaty. This treaty says, the state parties to this treaty, inspired by the great prospects opening up before mankind as a result of man's entry into outer space, recognizing the common interest of all mankind in the progress of the exploration and use of outer space for peaceful purposes, believing that exploration and use of outer space should be carried on for the benefit of all peoples irrespective of degree of their economic and scientific development, desiring to contribute to broad international cooperation in the scientific as well as legal aspects of exploration and use of outer space for peaceful purposes, believing that such cooperation will contribute to the development of mutual understanding and the strengthening of friendly relations between states and peoples. Having agreed on the following, Article 1 says, the exploration and use of outer space, including moon and other celestial bodies, shall be carried out for the benefit and in the interest of all countries, irrespective of their degree of economic scientific development, and shall be province of all mankind. Article 2 says, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. So it says, outer space cannot be made subject to claim of sovereignty of any particular state. But if you read it carefully, you will notice that it says it cannot be a subject of national appropriation. It does not say anything about private appropriation, means use or claim on outer space by a private entity or an individual. It speaks about national appropriation, right? So that's very interesting. And this becomes even more interesting when you read Gregory's reply to NASA's reply. Let's read this. Orbital Development's response to NASA's reply on Eros parking fee invoice. Thank you for your letter dated this in response to Orbital Development's invoice. As you have requested in further clarification of my ownership status, I will attempt to provide acceptably facial supporting information about my claim to ownership of the property. Multiple facets of the law allow support of the claim. Because my response addresses several points of discussion, it is probably most appropriate that the Department of State be made aware of our difference of opinion as the space property rights issue and my right to invoice NASA for submitted request of payment of fees now past due. Now he starts explaining his claim, and let's jump to the part where he starts talking about claim in law. He says, your letter cites Article 2 of the Outer Space Treaty, to which the United States is a party, which states, and we have read what it states, outer space including the moon and other celestial bodies is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. He says, a natural person appropriated the claim for 433 Eros, myself. The claim was specifically not instituted on behalf of any nation. Your citation above does not address the situation of personal claims by appropriation, it solely addresses national appropriations. My claim's full intention is presented here for your consideration. Complete control in fee simple or outright ownership, free and clear, specifically not instituted on behalf of any nation, and regard it as real personal property owned by Gregory Nemitz, a natural person. So he is distinguishing that the Outer Space Treaty speaks about a national appropriation, but he is talking that I am claiming as a property as a natural person, and the treaty does not speak about appropriation by natural person. So it says Outer Space Treaty does not apply to me. It may apply to the US, but it does not apply to me as a private individual, as a natural person. So my claim is valid. That's what his claim is. So after that, there's a lot of back and forth between him and NASA and the US Attorney's Office, and ultimately his claim is dismissed. And the basis for dismissing his claim was the interpretation of Article 2 of the Outer Space Treaty. Even though it speaks about national appropriation and does not expressly say anything about private appropriation or private ownership of any part of our outer space, what is property right in the first place? Say, if you own something, your ownership means nothing if there is no state to enforce it. If you think about it, if you have to press a claim that you own a particular piece of land or any movable or immovable property, that claim is meaningless unless you cannot enforce it. And how can you enforce it? You can either enforce it by having your own police force, or in our case, we enforce it by trusting or entrusting this function of enforcing property rights to the state. So when we live in this state and the society scenario, the society and the individual claims for ownership of property is only sustained because it is backed up by the force of the state. And if you apply this to the outer space, even if you can say that I own this piece of land in the outer space, or I own this piece of celestial body, can you really enforce that claim? Does that claim have any meaning without any support of the state? So that is one reasoning given to interpret Article 2 as including private individual as well. So the interpretation which currently stands is that outer space, including the moon and other celestial bodies, is not subject to national appropriation and also by private appropriation, because private appropriation is meaningless without national or state backing. And this interpretation has now gained the status of customary international law. So this is the settled position. Article 2 includes both private and public appropriation. That's why this argument can no longer stand. The argument that Nemitz took can no longer stand.